So when I met with Tom and others to try to develop this, I said the basic thing that I've taught, and I've taught trial practice at the law school, is I try to teach people, particularly new lawyers, from the point of view of analyzing the elements of a cause of action. And so everything that you've got, whether it's a protection of abuse claim, whether it's a lead paint case, whether it's a medical malpractice case, any kind of case whatsoever, they all have elements, and you know that from law school, you know, and you were trained to be able to, so what are the elements of such and such, and you should be able to then, you know, list them off. And I train from that point of view because the largest hazard for any trial lawyer is to have a cause of action which has 6 elements, but you only prove 5 of them. Because there was no reason to come into court on day one anyhow, because you're going to lose, you're just going to get dismissed, because you had to prove 6, but you only proved 5. So I come from the point of view, and it's a very simplistic point of view, that in all cases, at the very least, sort of the minimal basic case has got to be some credible evidence on every single element of the claim, regardless of what the kind of claim is. And so if you again have a claim that has 6 elements, you better have something on each of the 6 elements, even if it's just an inference. That's enough. Okay, inferences are still, it's circumstantial evidence, it's all good. Okay, but you got to have something on every single element. If not, there's no reason to go to court. Okay, you should have settled, you should have never brought the claim in the first place. And so that's where I start from. And so again, it's relatively simplistic. The thing is that once you've proven those basic elements, then you can throw in anything you want on top of that. You put the icing on the cake. Okay, then you worry about, you know, how appealing am I going to make the case? How appealing am I going to make my client? What other kinds of things can I add in to really get the judge's or the jury's attention so they're going to want to side with my side of the case? Everything else becomes sort of added on, fluff. It may be the theme of the case. You've probably heard plenty of stuff if you've gone to seminars about trial practice, you know, developing the theme of the case. Theme means nothing if you've left out an element of the cause of action. You can have a great theme, but it's going to be a directed verdict or judgment, you know, right after you say, I rest. That's it. Boom, you're done. Okay? So, very simple method. And so I'll use just as an example to start us off with. If you had a negligence case, for those of you who can remember from law school, okay, and you don't have to remember it because it's very funny because I've taught in the law school and I would teach like third-year students. I say, remember negligence that you studied 2 years ago? What are the elements of negligence? And they're like, I don't know. Okay, so you got to have a duty, you got to have a breach, you got to have causation, and you got to have damages. Okay? 4 things. If you miss any one of those 4 things, there'd be no reason to come to court, right? Or likewise, if you had evidence of all of those 4 things, but you forgot, okay, and you rest, well, contact your malpractice carrier, okay? So what I do generally with this kind of analysis is pretty simple. There's not enough space on this board, but you'll get the idea, is what am I trying to prove in regards to the duty? Okay, and so let's say it's an automobile accident case. What's the duty? Well, so it's, you should have looked left, before you made the turn, okay? Breach, you didn't look left before you made the turn. Causation, collision occurred, arm broke, damages, went to hospital, blah, blah, blah. Okay, so this is the this is the general, what am I going to prove? And I can cross those out. I mean, as I present my case, I have plaintiff take the stand, okay, driving an automobile, okay? You saw the defendant, yes. The defendant took a left-hand turn, yes. Took a left-hand turn right in front of you when they were supposed to have stopped, whatever. I mean, I can go through these things and cross them off as I prove them. So then I look at witnesses, exhibits, and other. How am I going to prove this? And this is all done before you get to trial. And so a lot of what we're talking about here, we will talk a little bit about trial techniques, things to do actually in court. But a good chunk of this is trial preparation. And so as you're sitting there in your office, or you're in the shower, okay, or you're making lunch, or whatever, you're thinking, how am I going to prove the duty? Do I have a witness? Do I have an exhibit? Do I have something else which is going to prove the duty that in this kind of a circumstance, somebody has an obligation to do X? Okay, and you know, this kind of a case, automobile accident case, probably all you're going to do is you're going to say, you know what, there's a statute that I'm going to have in my jury instructions that's going to be enough to prove duty. Don't have to do anything else on top of that. But you know what? When I get the defendant on the stand under the witness column, I'm going to say, well, you understood you were coming to an intersection? Yes. You understood you had an obligation to X? Yes. And you understood that the reason you had that obligation to do that was because if you didn't, you might cause an injury? Yes. So I can, through a witness, also establish a duty. Breach, what do I have for evidence there? Do I have witnesses? Do I have exhibits? Do I have other things that I can rely upon? Same with causation, same with damages, you go across the line. Questions with this technique, and it just is it's a very basic kind of technique. Questions? Please jump in.